Groundviews is speaking with Asanga Welikala, Senior Researcher at the Center for Policy Alternatives. Asanga, thank you for joining us. Very briefly, Asanga, today we got to know that journalist J.S Tissainayagam has been released on bail. We understand that there had been many requests for bail that had been refused in the past. What's different now? Why has this application and why is he succeeded and why is he on bail as we speak?
Well, as we know, the bail was refused during the currency of his investigation as well as the trial. For various reasons, the police objected to bail being granted and him being enlarged on bail. But now that he has been convicted and is now currently started serving, but in the context of his appeal against his conviction to the Court of Appeal, there is a general practice that in cases which are not very serious, that bail is generally granted, and in this case we know also that he has very serious health problems, and the court obviously has taken that into account, and on health grounds he has been now granted bail.
I mean, just to probe that further, these are not conditions of ill health that were not known in the past. These have been repeated. The concerns regarding his health and in particular his eyesight were articulated on a number of occasions, both during the trial and indeed after it. Perhaps to ask you a pointed question, why now again has he been released, or rather, as you say, enlarged on bail?
Well, it's difficult to answer that question. As you rightly say, the reasons of his health were always brought before court, particularly in relation to the bail applications in the past. But I cannot answer that question. All I can say is that we are very happy that the court has felt able to agree with his application and on health grounds to grant him bail.
Asanga, what does this exactly mean? Could you just briefly explain what happens now to Tissa, or what could happen? Does it mean that he has, obviously it does not mean that he has been acquitted, but is there the possibility of him going back into prison, and if so, how could such a scenario arise?
Well, it entirely depends on the appeal. In this country, appeals take quite a long time. He has been convicted, he has been sentenced. His appeal is pending. He is entitled to that, to both the Court of Appeal and thereafter to the Supreme Court. And until that process is over, obviously, his conviction remains valid. So absolutely you're right, he's not acquitted. Only thing that is here is that he will not be in remand custody. He will be allowed to stay at home. But I don't know exactly what the conditions of the bail grant has been. But it is unlikely that he would be allowed, for example, to leave the country. But whatever the case is, he can now be at home and prosecute his appeals against his conviction from the relative comfort of his home.
And if it were to be the case that, I mean, as you said, it is not that he is acquitted. So if one were to suggest to the court that he needs to be put back into prison, if that argument were to be made, who would make that? How would it be made? Would it be the police submitting that? In what context could such a request be made? Maybe to just give the lay of the land of the legal framework involved in that.
Absolutely. Well, I mean, it is generally unlikely that he is going to be put back into prison unless, of course, his conviction is upheld and his appeal refused by the Court of Appeal or subsequently the Supreme Court. In which case, of course, he'll have to go back to prison to serve out his sentence. But it's unlikely during the pendency of the appeal, however, that he will be put back into prison. But if that were to happen, that would happen at first instance if he were to violate the conditions of his bail. For example, if he's not allowed to go out of the country, if he does, then clearly his bail would stand cancelled immediately. There may be other reasons that the police might think that it is better to have him in custody, but those are very remote possibilities.
In recent years, Asanga, as a final question, Tissa's case in particular, with the the murder of Lasantha Wickramatunge commemorated just a few days ago in 2009, these were constantly referred to as two cases in Sri Lanka where the freedom of expression and media freedom in particular were put under scrutiny. With Tissa being now out on bail, do you see in the future the conditions with regard to media freedom and the freedom of expression improving in any degree? I mean, you've said that this is a positive a step taken by the courts and the government? Do you see this as one of many more in the future to strengthen FOE and media freedom in the country?
A very small yes and a very big no. Yes, because I'm naturally, along with all of us, we are very happy that this friend and colleague his nightmare within prison has come to an end to some extent at least, and that he is able to rejoin his family, friends, colleagues outside while his appeal is going on. No, because the very reason that Tissa has been put through this ordeal, both in terms of a criminal conviction as well as the remand prison experience, the interrogations in the TID, all of that ought not to really happen in a civilized society, and those problems still remain. Those problems are the criminalizing of the freedom of expression in the Prevention of Terrorism Act, the PTA, the emergency regulations. All of those things are still on the statute book, have no place absolutely in a civilized society, and to the extent that those things are not repealed and taken away, the threat remains very much alive for the freedom of expression and democracy in Sri Lanka.
Asanga, thanks very much for joining us.
Thank you.